preservation of and increased access to the 92nd Street Y Humanities Audio Archives is generously funded by the National Endowment for the Humanities.
Good evening. I'm Laura Kaminsky, Associate Director of Education, and it's my pleasure to welcome you to the Y for the second evening of our four-part series on the Bicentennial of the Constitution. The 92nd Street Y is pleased to acknowledge Philip Morris Companies Incorporated, which provided a generous grant in support of this series. An affiliated educational program is being made possible by the Albert A. List Foundation with the cooperation of the American Federation of Teachers. We are also pleased that, as part of our general programming for teenagers here at the Y, we have arranged for a group of 30 high school students to attend all 4 evenings of this lecture series, and for them to participate in pre-lecture dinner and discussion sessions in which they have the opportunity to talk further about the topics covered throughout the series. We're delighted by this response. I'd ask you to stand, but 30 people getting up at once may be a bit clumsy, so enjoy the evening. The format tonight is as follows. In just a few minutes, selections from the Federalist Papers will be read aloud, providing the context and historical perspective for the ensuing discussion. Following the reading, our moderator, Professor Richard Morris, will present his introductory remarks and will welcome our distinguished guests tonight, Griffin B. Bell and Wade H. McCree Jr., who will then join him on stage for discussion of tonight's topic, individual liberty and civil order. In about 45 minutes into their conversation, ushers will come down the aisles to collect your questions, which you will have written on the index cards you received upon entering the hall. I'd like to take but a moment to introduce our reader for tonight's excerpts. Eric Swanson is a 1981 Theater Studies graduate of Yale University with a 1985 degree from the Juilliard School Drama Center. Mr. Swanson's recent Broadway credits include You Never Can Tell. Off-Broadway, he has been seen in The Misanthrope and The Waltz of the Toreadors at the Roundabout Theater. Most recently, he has narrated Jerome Robbins' Fanfare at the New York City Ballet. It is an honor and a pleasure to welcome back our series moderator, Richard B. Morris, the Gouverneur Morris Professor of History Emeritus and editor of the Papers of John Jay at Columbia University. He is past president of the American Historical Association and the Society of American Historians, and is a trustee of the John Jay Homestead. He is author of numerous books in American history, including Government and Labor in Early America, the Bancroft Prize-winning The Peacemakers, The Great Powers and American Independence, and the Encyclopedia of American History, now in its 6th edition. He is co-editor with Henry Steele Commager of the New American Nation series, a multi-volume re-examination of the history of the American people, and currently author of 2 books on the framing of the Constitution, Witnesses at the Creation, Hamilton, Madison, Jay, and the Constitution, and, to be published this May, The Forging of the Union, 1781 to 1789. He is co-chair with James McGregor Burns of Project 87, an organization jointly sponsored by the American Historical Association and the American Political Science Association to stimulate nationwide study and understanding of the Constitution. Please join me in welcoming our guest, Richard Morris. Thank you.
The Federalist, number 9, Hamilton, November 21st, 1787. To the people of the state of New York, a firm union will be of the utmost moment to the peace and liberty of the states as a barrier against domestic faction and insurrection. The regular distribution of power into distinct departments, the introduction of legislative balances and checks, the institution of courts composed of judges holding their offices during good behavior, the representation of the people in the legislature by deputies of their own election, these are either wholly new discoveries or have made their principal progress towards perfection in modern times. They are means, and powerful means, by which the excellencies of republican government may be retained and its imperfections lessened or avoided. The Federalist number 10, Madison, November 22nd, 1787. To the people of the state of New York, among the numerous advantages promised by a well-constructed union, none deserves to be more accurately developed than its tendency to break and control the violence of faction. The friend of popular government never finds himself so much alarmed for their character and fate as when he contemplates their propensity to this dangerous vice. By a faction, I understand a number of citizens, whether amounting to a majority or minority of the whole, who are united and actuated by some common impulse of passion or of interest, adverse to the rights of other citizens or to the permanent and aggregate interests of the community. There are two methods of curing the mischiefs of faction, the one by removing its causes, the other by controlling its effects. There are again two methods of removing the causes of faction, the one by destroying the liberty which is essential to its existence, the other by giving to every citizen the same opinions, the same passions, and the same interests. The latent causes of faction are sown in the nature of man, and we see them everywhere brought into different degrees of activity according to the different circumstances of civil society. A zeal for different opinions concerning religion, concerning government, and many other points, as well of speculation as of practice, an attachment to different leaders ambitiously contending for preeminence and power, or to persons of other descriptions whose fortunes have been interesting to the human passion, have in turn divided mankind into parties, inflamed them with mutual animosity, and rendered them more disposed to vex and oppress each other than to cooperate for their common good. So strong is this propensity of mankind to fall into mutual animosities that where no substantial occasion presents itself, the most frivolous and fanciful distinctions have been sufficient to kindle their unfriendly passions and excite their most violent conflicts. The inference to which we are brought is that the causes of faction cannot be removed, and that relief is only to be sought in the means of controlling its effects. The influence of factious leaders may kindle a flame within their particular states, but will be unable to spread a general conflagration through the other states. A religious sect may degenerate into a political faction in a part of the Confederacy, but the variety of sects dispersed over the entire face of it must secure the national councils against any danger from that source. A rage for paper money, for an abolition of debts, for an equal division of property, or for any other improper or wicked project will be less apt to pervade the whole body of the Union than a particular member of it, in the same proportion as such a malady is more likely to taint a particular county or district than an entire state. In the extent and proper structure of the Union, therefore, we behold a republican remedy for the diseases most incident to republican government, and according to the degree of pleasure and pride we feel in being republicans, ought to be our zeal in cherishing the spirit and supporting the character of Federalists. The Federalist number 22, Hamilton, December 14th, 1787. Laws are a dead letter without courts to expound and define their true meaning and operation. The treaties of the United States, to have any force at all, must be considered as part of the law of the land. Their true import, as far as respects individuals, must, like all other laws, be ascertained by judicial determinations. To produce uniformity in these determinations, they ought to be submitted in the last resort to one supreme tribunal, and this tribunal ought to be instituted under the same authority which forms the treaties themselves. The fabric of the American empire ought to rest on the solid basis of the consent of the people. The streams of national power ought to flow immediately from that pure, original fountain of all legitimate authority. The Federalist number 23, Hamilton, December 18th, 1787. To the people of the state of New York, the Union ought to be invested with full power to levy troops, to build and equip fleets, and to raise the revenues which will be required for the formation and support of an army and navy in the customary and ordinary modes practiced in other governments. A government, the constitution of which renders it unfit to be trusted with all the powers which a free people ought to delegate to any government, would be an unsafe and improper depository of the national interests. Wherever these can, with propriety, be confided, the coincident powers may safely accompany them. The Federalist number 24, Hamilton, December 19th, 1787. Restraints upon the discretion of the legislature in respect to military establishments in time of peace would be improper to be imposed, and if imposed from the necessities of society, would be unlikely to be observed. The Federalist number 25, Hamilton, December 21st, 1787. To the people of the state of New York, all violent policy, contrary to the natural and experienced course of human affairs, defeats itself. Nations pay little regard to rules and maxims calculated in their very nature to run counter to the necessities of society. Wise politicians will be cautious about fettering the government with restrictions that cannot be observed, because they know that every breach of the fundamental laws, though dictated by necessity, impairs that sacred reverence which ought to be maintained in the breasts of rulers toward the constitution of a country, and forms a precedent for other breaches, where the same plea of necessity does not exist at all, or is less urgent and palpable. Federalist number 26, Hamilton, December 22nd, 1787. The idea of restraining the legislative authority in the means of providing for the national defense is one of those refinements which owe their origin to a zeal for liberty more ardent than enlightened. The Federalist number 27, Hamilton, December 25th, 1787. To the people of the state of New York, it has been urged in different shapes that a constitution of the kind proposed by the convention cannot operate without the aid of a military force to execute its laws. The Federalist number 28, Hamilton, December 26th, 1787. To the people of the state of New York, that there may happen cases in which the national government may be necessitated to resort to force cannot be denied. Our own experience has corroborated the lessons taught by the examples of other nations, that emergencies of this sort will sometimes arise in all societies, however constituted, that seditions and insurrections are unhappily maladies as inseparable from the body politic as tumors and eruptions from the natural body, that the idea of governing at all times by the simple force of law, which we have been told is the only admissible principle of republican government, has no place but in the reveries of those political doctors whose sagacity disdains the admonitions of experimental instruction. Should such emergencies at any time happen under the national government, there could be no remedy but force. The means to be employed must be proportioned to the extent of the mischief. The whole power of the proposed government is to be in the hands of the representatives of the people. This is the essential and, after all, the only efficacious security for the rights and privileges of the people, which is attainable in civil society. It may be safely received as an axiom in our political system that the state governments will, in all possible contingencies, afford complete security against invasions of the public liberty by the national authority. And finally, the Federalist number 29, Hamilton, January 9th, 1788. To the people of the state of New York, the plan of the convention proposes to empower the Union to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. If a well-regulated militia be the most natural defense of a free country, it ought certainly to be under the regulation and at the disposal of that body which is constituted the guardian of the national security. What reason could there be to infer that force was intended to be the sole instrument of authority merely because there is a power to make use of it when necessary? What shall we think of the motives which could induce men of sense to reason in this manner? How shall we prevent a conflict between charity and judgment?
Good evening, ladies and gentlemen. This series of symposia is focused on the Constitution, what it is and how it works, and has quite properly turned to the letters of Publius, known as the Federalist, for some of the answers. Written here in New York City between October 1787 and June of 1788 by three superstars, Alexander Hamilton, James Madison, and John Jay, it combines insights, scholarship, and a freshness of approach that has made that collection of newspaper pieces, brought together in book form by Hamilton later, an enduring classic. How this trio of contributors presented reasoned arguments for the adoption of the Constitution, whose fate seemed in doubt in Virginia and New York, how their reassurance to a bankrupt nation won friends for the Constitution in the great battles over ratification is in itself a literary epic. At our first symposium, we heard excerpts from the Constitution, so tonight it is appropriate that in a session devoted to individual liberty and civil order, we have heard some pertinent passages. With one exception, all the excerpts we have heard were penned by Hamilton, that great exponent of the need for conferring upon the central government authority to maintain civil order and defend the national interest. All except one, and that the famous number 10, still the most quoted of all the Federalist letters, was written by James Madison, the great exponent and defender of individual liberty and minority rights. Indeed, all three writers were concerned with liberty, but what was especially troubling these writers, indeed Madison as much as Hamilton, was the rebellion then raging in Massachusetts under the leadership of Daniel Shays, one that required a state-backed but privately financed army to put down. What if that happened again? Should not the federal government have a sufficient standing to put it down? You may have observed, on listening to these excerpts from the Federalist, that virtually all of them are concerned with public order and defense. The exception is Madison's number 10. Madison's emphasis on property rights and his concern with creditors has been regarded by some critics as evidence of the economic interest of the framers of the Constitution. Others, and I am one of them, see it differently. They regard Madison's concern with property rights as reflecting a Lockean traditional outlook toward the protection of property as the basic guarantee of individual liberty. John Adams' defense of the Constitution regarded property as surely a right of mankind. What Madison feared was an invasion of property rights by an unchecked majority. Only by securing public and private rights could one preserve popular government. But as a matter of fact, there is then very little that we can find in the Constitution about private rights, except, for example, for a clause against ex post facto legislation, against bills of attainder, and a few other matters. So that was not enough for the ratifiers, who insisted that the Constitution would not, in some of the states, Constitution would not be ratified without a Bill of Rights to guarantee that there would be individual liberty as well as civil order. To discuss these issues this evening, we are honored by the presence of two distinguished exponents and practitioners of law enforcement and civil rights who have managed with signal success to maintain that delicate balance between individual liberty and civil order. Judge Griffin Bell is acknowledged as one of the leaders of the American bar. He is president of the American College of Trial Lawyers and a member of the American Law Institute. His distinguished term on the United States Court of Appeals for the Fifth Circuit, while briefly terminated by a return to the practice of the law with the prestigious Atlanta firm of King and Spalding, was followed by his appointment by President Carter as Attorney General of the United States, a post he held until his resignation in 1979. Griffin Bell was one of the few attorneys general in our history to be seriously concerned with the reform and organization of the legal branch of the government. And in that regard, he ranks with Edmund Randolph, Caleb Cushing, and Homer Cummings. Working with the president, he established merit selection panels to choose Court of Appeals judges and promoted other notable reforms. Known for his fine sense of humor, Griffin Bell, it might be added, chose to argue before the Supreme Court the case involving the 3-inch snail darter. He held up a glass vial containing a snail darter and waved it at the bench. Incidentally, Wade McCree, who's going to be with us tonight too, sat on the case as the judge of the Sixth Circuit. True, the United States lost the case in the Supreme Court, but soon won it in Congress, which voted to let the dam, a $100 million project, be built. The little fish, too, survived in other streams. Lastly, I might point out that as Attorney General, Griffin Bell was responsible for the appointment of more female judges than the total of all other administrations. It is most appropriate that Judge Bell's colleague in the Department of Justice should join in this symposium tonight. For Wade McCree served under Judge Bell as Solicitor General of the United States. But before then, he had enjoyed a distinguished judicial career, first as circuit judge in Wayne County, Michigan. Then, in 1961, he was appointed to the United States District Court for the Eastern District of Michigan, where he served for 5 years until his appointment to the United States Court of Appeals for the Sixth Circuit. Suffice to say that subsequently, as Solicitor General, he filled that post in the great tradition of predecessors of the stature of William Howard Taft, John W. Davis, Robert Jackson, and Archibald Cox. He resigned that position to accept appointment as Lewis M. Symes Professor of Law at the University of Michigan. Wade McCree has served in so many other governmental capacities, as well as what I have mentioned, that a full account would preempt this entire meeting. But I should add that among his important memberships and trusteeships, he serves on the board of the Detroit Round Table of the National Conference of Christians and Jews, and is a life member of the National Association for the Advancement of Colored People. Finally, Professor McCree set some kind of record for the number of honorary degrees he holds from prestigious universities, all a fitting tribute to his distinguished career in the public service, his legal scholarship, and his wonderful qualities as a human being. I shall now turn this meeting over to Judge Bell and Professor McCree, who in turn will favor us with some opening remarks. Thank you.
Ladies and gentlemen, we are in the middle of our constitutional season. It began 200 years ago, plus 15 years, 1776. It will end in 1991, which is just 15 years after the Declaration of Independence. That's when the Bill of Rights was ratified. We are celebrating the Bicentennial all over this country. I've been in a number of places already this year, because this is the year that the Constitution was written. It's dedicated in large measure to individual liberty. It is heavy with the philosophy of Thomas Jefferson, who was not at the convention. He was absent because he was our ambassador to France and was in Paris. He kept in close touch with Madison by writing letters to him and sending different kinds of information to him on the political philosophy and political writings. What they were able to do in Philadelphia was to give us a structure of government which would make it possible for our individual liberty to evolve over the years. We have a unique government because we have a division of separation of powers between the three great branches of the government. We have all the checks and balances which we see almost daily in operation. But the Constitution was not complete. It did not complete the structure that we needed if we were to have the maximum in freedom and individual liberty. John Marshall had to author the great opinion of Marbury versus Madison to decide who was going to construe the Constitution and whether the laws that Congress passed were constitutional. Then that was one thing that had to be done. The other one was, of course, the Bill of Rights. The great concern in the colonies because there was no Bill of Rights. That was promptly remedied at the first Congress, which met here in New York in 1789. And the last thing that had to be done to make the system perfect, and I think it is as near perfect as a government could be, a structure, was the 14th Amendment. We had nowhere anything in the law itself or in the Constitution which provided for the equal protection of the laws, that each one of us would have equal protection of the laws. That was not in the Bill of Rights. And in a great country with a diverse population like we have, I doubt that we could have survived without an equal protection clause. That amendment only applied to the states as against the states, which the Supreme Court later held that the due process clause of the Fifth Amendment contained an equal protection clause as against the federal government. So that made it complete. New York's role was to be the capital, first capital, and where the first Congress met. The weather apparently was not too good because Mr. Jefferson, he wrote down everything. He wrote that the weather was not good here. As near as he could tell, they had 10 months of winter, 2 of summer, no fall and no spring. The most remarkable thing to me in the whole constitutional convention and the ratification which followed shortly thereafter was the fact that these 13 states had banded together and they had Articles of Confederation in which everything had to be unanimous. and they were all jealous of the power, the little states against the big states. And in the last part of the Constitution, they provided that the Constitution would become effective when it was ratified by just 9 states. And that was really a shift of power, a great giving up of power. Without that, the Constitution would not have been ratified, and we would not have had a Constitution for a long, long time, if ever. But 9 states quickly ratified, and that put the Constitution into effect. We then had the old Congress of the Confederation adjourned, sine die, and we had an elected President Washington as our first president, and John Adams, who didn't have political parties. John Adams got the next largest number of votes, became the vice president. The structure of the government from the standpoint of order as against their rights was that the police power was left in the states, and the military power was placed in the federal government. But everything was subject to the Supremacy Clause, which meant that the Constitution took precedence over any law, state or federal, or any act, state or federal. And then you have to accommodate everyone's rights, freedom within that context. And I have a shorthand that I follow, and that is that I'm entitled to the maximum freedom, so long as my freedom, up to the point where my freedom collides with someone else's freedom. And that's really how the system operates in our country. We can do anything that we want to do so long as we don't interfere with someone else. And sometimes we can even do that. But that's a general rule. I think that the Constitution is a great document. I think the title of the book, Miracle of Philadelphia, is a good description of it. Dr. Dumas Malone, who was a great biographer of Jefferson, died recently. But in his last volume on Jefferson, The Sage of Monticello, he was writing about his 39-year journey with Jefferson while he wrote the biography. And he said that Jefferson was perceived eternal values and supported timeless causes. And because of that, he became a great champion, perhaps the world's greatest champion of freedom and enlightenment. And I think as we celebrate our Constitution, we ought to have in mind that it is has eternal, it is of eternal value, and it is timeless. It's been amended only a few times in 200 years, and if you consider every amendment of serious import today, that anyone could suggest it would not be more than 3 or 4 things that people would suggest that needed even to be changed at all about the Constitution. It's timeless and eternal. Thank you very much.
Good evening, and by way of commencement, I want to thank Professor Morris for his very generous introduction and to tell you how pleased I am to be here this evening with my old friend Griffin Bell, with whom and under whom I had the privilege of serving in the government in Washington. And I can assure you that there's no finer lawyer or patriot in this country. I also recognize that this is perhaps the preeminent forum in the United States, and I consider myself privileged to have the opportunity to participate in this inquiry into the fundamental document which guides our government and us through its ministrations as we celebrate this 200th year of its existence. I'm a lawyer, as is Griffin Bell. He was introduced as head of the American Trial Lawyers Association. and lawyers in their initial communication to the jury or to the court make what's known as an opening statement, which is not a profound or an exhaustive document at all, but an outline of what they propose to talk about. And that's what I intend to do in the next few minutes, to tell you what I would talk about if we would go through the entire enterprise, which we won't because we have a terminal point at 10 o'clock this evening. And the best part will come when you will have the opportunity to stimulate Judge Bell and me with your questions and comments to which we can react. I view the Constitution as an instrument that was intended to accomplish three things, essentially. First, to apportion the powers of government between the several states, which had made pretty much of a mess of things under the Articles of Confederation, and the federal government. That was the first thing. What powers should remain with the states and what should be in this new government which was to be invested. And second, within the new government, how should these powers be separated? How should they be balanced so that there could never be a sufficient concentration of power in any one place to tempt someone to the tyranny of oppression? That's the second objective. And the third objective, to preserve individual liberties. We heard the reading and these beautiful stentorian tones of our first performer this evening of certain numbers of the Federalist Papers, which, as we know, are arguments made to persuade New York and other states that might read them, citizens of other states who might read them too, to support the new Constitution. And you notice that there was a singular absence of any reference to individual liberties. The dialogue concerned the concentration of power, control of the armed services and the militia, and the ways to prevent factious elements of the population from impeding the progress of the whole national enterprise. And hardly anything was said about individual liberties because the original Constitution said very little about individual liberties. So little, as a matter of fact, as we all recognize, that its ratification was endangered because of this significant absence. And it wasn't until there was a tacit understanding that a Bill of Rights would be adopted as soon as the Constitution should have been ratified that the document received the breath of life. And indeed, in 1791, the first 10 amendments, called the Bill of Rights because they came in a package, were duly adopted. Even those left a great deal to be desired, and I'll sketch that very briefly. In the original document, the several limitations to which reference has been made would not be deemed significant to us today as we think about what constitute individual liberties. Prohibition against a bill of attainder. Has anyone here ever been attainted or threatened with it? Or prohibition against ex post facto laws. Some of us feel that way when we look at the Internal Revenue Reform measure, but that's prospective. Believe me, it's hard enough being prospective to accept. The reference has been made, though, to one provision that was included in the original Constitution, and that's Article 4, Section 2. The citizens of each state shall be entitled to all privileges and immunities of citizens of the several states. Now that might sound like the investment of rights or privileges, but it really didn't work that way. As it was construed, it just meant that you had to treat everybody in the same way, and it had the effect of a leveling measure. Instead of elevating everybody to a height, it just meant that you could descend to the depths as long as you took everybody with you. And that's almost everybody, and I'm almost through with my opening statement, too. The other guarantees were to protect the United States in the one practice of which it was thoroughly ashamed. It provided for representation in the Congress of the new nation, just male persons who were entitled to vote, and just Caucasian people. But it counted 3/5 of others, except Indians, to determine the number of representatives to which a state would be entitled in the lower house. It also contained a provision that the importation of such persons as a state might deem appropriate, that's a circumlocution for slaves, could not be interdicted or prevented before 1808. And it also provided for the rendering over of persons who have escaped from labor, which again was another circumlocution for a fugitive slave provision. It's interesting that the word slave doesn't appear in this document of freedom. It just wouldn't belong there. And it bothered this nation until it fought a great war, in part to eliminate that institution. And then it followed with 3 significant amendments, the 13th, 14th, and 15th Amendments, which for the first time obligated the states, as well as the federal government, which was obligated in 1791 by the Bill of Rights, to accord genuine rights, privileges, and liberties to everybody in the United States of America. And the unfinished agenda of our nation is to give those rights their full meaning and their full implementation. And when we do that, we'll have something more to celebrate than just having lasted 2 centuries, which is a sufficient reason anyway. I close my opening statement by saying that there have been many nations which have copied our Constitution or written one just like it, and they haven't endured nearly as long as our nation has with this Constitution. So it takes something in addition to the written pages of this Constitution to permit us to do this. It takes the commitment of people, and I'll have something more to say about this later, at least if one of your questions doesn't stimulate it. I'll have a way to twist it, so I'll say it anyway. Thank you.
Now, I'd like to start the discussion by putting a question to Judge Bell, starting it in the form of a statement. One of the great surprises of the Constitution was the strong powers that were given to the chief executive. That is a consideration which is not discussed in Publius or the Federalist for some later readings. But that was an unusual provision, considering the fact that the American Revolution was fought against the alleged tyranny of George III, and that only 2 state constitutions, Massachusetts and New York, had relatively strong state governors. And I wonder, to what extent, Judge Bell, do you think the fact that there was a gentleman presiding over the Constitutional Convention known as George Washington, and that most people had a hope that George Washington would be the first president of the United States, that not only persuaded the framers of the Constitution to invest the president with such great powers, but at the same time persuaded the ratifiers at the ratifying conventions to accept this very strong executive, which ran contrary to the Republican tradition which was growing out of the American Revolution?
Well, as you know, many of the delegates wanted to make George Washington king, and he didn't want to be king. Otherwise, we might have ended up with a king. But the president's power is not as great as people think it is. He has Satan power. He's empowered to run the foreign policy. But I'm not saying just who's running it. That is his prerogative, however. He is the only person in charge of faithfully executing the laws. And he does that through his appointments of the Attorney General and U.S. attorneys. That's what one of the legal issue is in the suit against the special prosecutor right now. The president has no money. Congress has to appropriate the money. And in my experience, the person with the money, whoever's in charge of the money usually wins. But that's part of the checks and balances. And I think that the Congress even has gotten very much into the foreign policy operation. One of the issues in the Iranian debate is whether President Reagan should have told the Congress about the secret, the covert operation he had going on with Iran. When that law was passed, I think Judge McCree and I were in the government at the time. There was a hot debate on whether you could force the president to disclose anything like that to the Congress, and we got these intelligence committees set up. Instead of reporting to 40 committees, we fixed it where we only reported to 2, one in the House and one in the Senate. But that's a close constitutional question. It's whether you have to report. Congress has got an oversight power. That's part of the legislative power, so they have a right to get information to carry out that function. They have the power to legislate. That's the 2 powers Congress has other than appropriating money and declaring war. They need to get facts so they know if we need more legislation. So you can argue it either way, but I'm not one that thinks the president is that powerful. We have been through this period of charismatic presidents, we'll call them, and I'm hoping we'll get a president who's not so charismatic.
Well, I just add a footnote to that point. Congress appropriates, and the president can't move without money, but at the present time, the president manages to get money without Congress, if he wants something done.
Well, I don't know about the president, but Lieutenant Colonel North seems to be able to raise money.
I have a question for Judge McCree in connection with the lack of material in the original Constitution on individual rights. Of course, we have habeas corpus, which can be suspended in times of civil commotion, and we have this business about the bills of attainder and a few other points. But there's also the guarantee clause, and I'm just wondering, which guarantees a Republican government and authorizes the President of the United States to send in federal troops on the request of the legislature and the governor of the state in terms of civil commotion and so forth. To what extent this guarantee clause, which provides for the maintenance of a Republican government, could be used on the basis of providing equal rights, where the violation of equal rights seemed to be contrary to the general principles of Republican government. Now, the guarantee clause has seldom been used in American history and seldom been thought about, but I'm just wondering what your views are on that subject.
Well, I, like you, am unaware of any construction of the guarantee clause to tell us what a Republican form of government means. I suppose it means a representative government. But beyond that, I don't know whether it has any substantive content. It would be my surmise that if someone asked the president to come in because some particular right or another was being denied or not granted or withheld from the populace, he would say, well, you have the right to vote, do you not? And if the answer was yes, he would say, then you have a Republican form of government. And I think that would be the end of it. As far as the other part about putting down insurrection, our history has recent instances of federal troops being sent at the request of a governor into a state to restore public order. We've had, unfortunately, in my state of Michigan, we had a riot in the 1960s when then Governor Romney of Michigan asked the president to send in some troops, as well as to federalize the National Guard for that purpose. But that's quite a different thing from invoking the guarantee of a Republican form of government. I don't know what it means. I don't think anyone knows what it means, and I don't think we'll ever have occasion to determine what it means, because I think if we ever reach that point, we will have passed the capacity of the Supreme Court to construe the action.
Following up on your other point, do you think that we would have had an enduring Constitution if we had not had the Reconstruction Amendments followed by the Women's Suffrage Amendment and the abolition of the poll tax, these kinds of changes which have taken place since 1865?
Oh, I certainly think that we would likely not have had an enduring government had it proved inflexible to respond to these tremendous movements that swept across the nation. It's the difference between steel and cast iron. One will bend and the other will break under pressure. And the Constitution has shown the resilience to adapt itself to changing conditions. And of course, that suggests what the real genius of the document is. I have in my hand the entire Constitution of the United States of America, which is considerably smaller than the automobile insurance policy for which I paid considerably more, and no more baffling in its terms. The genius of this document is that it speaks in generalities that had a meaning at one time, but are adaptable to a different meaning at a different time. And I think that's part of its growth. If you'll indulge me, I'll say something about a recent op-ed piece in the New York Times about 2 Sundays ago by a Professor Smalla from the University of Arkansas Law School, in which he compares the Constitution to the scriptural text in any religion that has written scriptures. And he says you can construe the text as being all determinative without interpretation, or you can accept the text with an oral tradition. And the religions that seem to grow and to have the flexibility have the oral tradition, and those that are bound strictly to the text cease to increase in numbers and influence. And it's a provocative thought, and I think this Constitution has those qualities, and I think Professor Smalla is to be congratulated for suggesting this metaphor to us.
Now, a last question, just for Judge Bell, a follow-up on this point about presidential power. Under the Constitution, the Congress declares war, and the president is commander-in-chief, so the president can make war. Now, ever since the Kellogg-Briand Treaty, nobody declares war because war is internationally illegal. People just make war. The question is, do you think that this clause needs a further definition or has become obsolete in usage?
No,
So the war powers of Congress?
I don't think so. I don't think the American people will let the government abandon that power. We couldn't get support for the Vietnam War. We've not had a popular war since World War II. The Congress did declare war in World War II. It unified the people. And I think it's part of our heritage and government as well that we have to have a declaration of war. Now, you can have these skirmishes around as a foreign policy operation, but they're mighty small and have to be well contained. But if we're going to be serious about a war, we have to declare war. have the Congress do it. We have to have the people to support anything that's serious.
May I add a postscript to that, Professor Morris? First, I agree entirely with Judge Bell that we must adhere to the constitutional provisions governing what we do there. The Congress, as we all know, has adopted the War Powers Act, which is an effort to reconcile the right of the president to be the duty of the president to be commander-in-chief of the armed forces with the right of the Congress to declare war. And as we know, it provides that if the president shall commit United States troops into military action, within stipulated periods of time, he's to report this fact to the Congress. And if he does not, the Congress is empowered to take what steps are appropriate, and I suppose they might be to cut off the funds necessary to continue the military operation. This act may have a flaw in it in that it might be analogized to a congressional veto, but it shows that the Congress means to perform its role, and as we look at what's happening in Central America today, the War Powers Act may very well be something with which we'll all become quite familiar with, God forbid.
Well, the precedent for Central America and Angola.
It certainly was not a precedent for Lebanon.
During the Ford administration, the Congress stopped the military assistance to Angola. But that question of whether the War Powers Act is constitutional, I don't suppose it'll ever be resolved because it's a political question. It probably won't be decided by a court.
Oh, I agree, a court won't decide it, but the American people, with their response to and instruction to their elected officials will decide it, will determine it.
All right.
I think now is an opportunity for this large and distinguished audience to provide us with questions which these two eminent authorities would like to answer, so that if we can just peruse them for a moment and this may be really for Judge McCree. Could you say a few words about how the Commerce Clause, rather than the 14th Amendment, was used to ban discrimination in public facilities?
Yes. The 14th Amendment, which is one of the Civil War amendments, provides in its pertinent part that no state shall deprive a person of equal protection of the laws. And the 14th Amendment interdicted state-sponsored or state-financed or state-influenced segregation or discrimination against someone because of race. There were private persons who discriminated against American people because of their race, and they could not be reached because of the construction placed on the 14th Amendment, and probably correctly so, because it does interdict the state's power to do it. And so the Congress had to find some way to reach private people. The Commerce Clause in Article 8 of Section 1 of the Constitution empowers the Congress to regulate the commerce between the states and among the Indian tribes and foreign nations. And it isn't limited to state action. And if the activity of the person who is discriminating imposed a burden on interstate commerce, it came within the power of the Congress to interdict it. And in its leading cases, I guess the first case was Heart of Atlanta Motel, that Judge Bell would know about from his home state in Atlanta, where interstate travelers were refused accommodations and food service and so forth. that could be reached through the Commerce Clause. And most of the statutes enacted during this so-called Freedom Rider period of our recent history were based both upon the 14th Amendment and the Commerce Clause, and as such received judicial enforcement and approbation. I want to add, too, that Judge Bell sat on the Fifth Circuit, which in the first instance entertained those cases and sustained this construction of the law, and he may have a footnote to what I have to say.
No, that was the Heart of Atlanta motel involved public accommodations. Black people traveling through the South couldn't stay in a hotel, couldn't eat in a regular restaurant, and otherwise couldn't travel. And it was thought by the Congress and upheld by the Supreme Court that that was a burden on, impermissible burden on interstate commerce. Perfectly logical ruling, I thought, and still think. That was just the way the ruling should have gone, and it should have been based on the Commerce Clause. That was one, if you study the history of the Constitution, one of the things that they were more worried about, I think more than anything else, was what to do about interstate commerce. One state would be interfering with another state's commerce. Wasn't so much foreign commerce as it was interstate commerce. And George Washington called a meeting between Maryland and Virginia over what to do about the Chesapeake Bay and the Potomac River about 2 years before the Constitutional Convention. And then they had another meeting at Annapolis, Maryland over that. So this Heart of Atlanta doctrine is very much in keeping with our constitutional history.
I think maybe this
This is one. What are your thoughts on the recent claims by Colonel North and Mr. Deva that special prosecutor's authority is unconstitutional? I alluded to that a minute ago. The argument is that the 3 judges appointed the special prosecutor on a law passed by Congress rather than the president. And that means the special prosecutor is faithfully executing the laws rather than the president, as the Constitution says. I don't know how that'll go. This question has come up before, but it was never decided, as I understand it, in some previous case. It's now pending in 2 different courts, and we're bound to get a ruling on it. I think myself it's a close case. I was once told by President Carter that he wanted to make the Attorney General more independent. This was, you understand, in the Watergate reform time, and he thought that the government would be better off to have an independent Attorney General who was neutral. He called it the neutral zone in the government. And our Office of Legal Counsel, when Judge McCree and I were there, we had a small office like the Solicitor General's office called the Office of Legal Counsel. They give the legal opinions to the President and to the Attorney General and the Cabinet officers generally, if they ask for one. And they have researched the matter in some depth and decided that the President couldn't make, the Congress couldn't make the Attorney General independent because that would mean the President was not faithfully executing the laws. So he would have to appoint someone else to help him faithfully execute the laws. That's the point in the special prosecutor case. I don't know how it'll come out.
May I add a footnote to that? I agree with Judge Bell's views about it. As I understand Colonel North's argument, or at least part of it, it is that the so-called special prosecutor was not appointed by the President, but by a 3-judge court, a special 3-judge court constituted in the act setting up the special prosecutor procedure, and as such is unconstitutional because it violates the separation of powers principle. Well, Article 2, which is the article having to do with the President, Article 1 being the one with the Congress and Article 3 with the courts, Article 2 provides in pertinent part, if you'll forgive me, I'll read 3 lines of it. The President shall appoint ambassadors, other public ministers and counsels, judges of the Supreme Court, and all other officers of the United States whose appointments are herein otherwise provided for, and which shall be established by the law. But the Congress may, by law, vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of the departments. So if we look to the special prosecutor as a so-called inferior officer because he's appointed for a limited purpose and a limited time, there's constitutional authority for the courts to appoint him. And that's part of Colonel North's argument. The other part, that it offends the separation of powers, is more esoteric because there's nothing in the Constitution that says explicitly that these powers shall be exclusive and not shared. And we just spoke of one, the War Powers Act, and when we discussed that, we showed that in many instances, different branches do indeed share the same power. But it'll be interesting to see what the courts say, because neither Judge Bell nor I is a commissioned judge presently, and neither will serve on that question.
This question was addressed to me for some reason. How important were the Federalist Papers in obtaining the ratification of the Constitution? Can you put them in some kind of historical perspective? Well, you know, the Federalist Papers were written in advance of the ratification of the Constitution in New York. It was written because the three authors felt that the ratification of the Constitution was in great jeopardy. In fact, the election of delegates to the Poughkeepsie Convention showed at the time of the opening of the convention, there was a 2.5 to 1 vote against the ratification of the Constitution. It's very difficult to judge the effectiveness of these newspaper letters, which were written at feverish haste and appeared 3 times a week in what amounted really to daily newspapers in New York, and also they were distributed elsewhere. I would say that the Federalist Papers were very important in the states of New York and Virginia. There, Madison in Virginia quoted frequently from him, as did John Marshall, who was one of his supporters, and a number of other of the eloquent spokesmen on behalf of ratification. In New York, Governor Clinton, who was, of course, the chairman of the ratification convention in New York, sneeringly referred to Hamilton as we're hearing a lot of Publius again, and so forth. So that in the debates in both New York and Virginia, which were of a very, very high quality, why the citations of the Federalists were very strong, one cannot prove that the Federalists turned the tide. It seems to me that the importance of the Federalists is as a classic exposition of the Constitution, which has had a profound effect on the 3 branches of the government, notably upon the judiciary. And it is used and cited by the courts with great frequency, and of course in stories, commentaries, and in John Marshall's decisions, and in other ways. We must remember also that it was a lawyer's argument that the 3 authors of the Federalist Papers were taking positions which represented, to some extent, a modification of their own private views. And we know, for example, that Madison, who in the Federalist Papers supported a very loose construction of the Constitution, changed his mind within a year or 2 and came to support a very strict construction of the Constitution, and actually joined with Thomas Jefferson in the formation of an opposition party, and ultimately in the writing of the Kentucky and Virginia resolves, which gave the states the right to interdict statutes of Congress which they felt were unconstitutional. But in any event, we look upon the Federalist not so much for its immediate effect, which is very, very difficult to measure, but rather for its long-range intellectual value and suggestiveness to those in power and to others like professors of constitutional law and exponents of the Constitution in classic form, like Kent's Commentary, Story, and others, who have found the Federalist to be the classic interpretation of the Constitution.
I think I might add to that there were people on the other side of the debate. I read something in the Wall Street Journal, a column by a professor, telling about one of the writers who called himself Brutus. And Brutus was complaining about the Constitution not limiting the number of terms that a senator or representative could remain in office. And he said that men long in office are very apt to feel themselves independent, to form and pursue interests separate from those who appointed them, so forth. And then he said, our senators will, for the most part, be absent from the state they represent and associate with such company as will possess very little of the feelings of the middle class. For it is to be remembered that there is to be a federal city, and the inhabitants of it will be the great and mighty of the earth.
I have another question here, which is, I think, addressed to Judge Bell. Did I turn that over?
Right, yeah, right.
Well, that's it. That's it.
This is the most profound legal question in the country today. Is being debated today. Is a United States Supreme Court decision binding on anyone besides the litigants involved in the case? This is a debate that started in London in 1984 at the American Bar meeting when Ed Meese made a speech saying something about this. It caused me to do a lot of research and to reflect on the question, and I gave a paper on this at the University of Kentucky a few months ago, pointing out that while the decision is only binding on the parties, that our country could not long survive if we all turned our back on court decisions and said we won't follow the decision until they take us to court. I lived through this for 10 or 12 years as a judge on the Fifth Circuit in the South, where we were nearly all of the white people were saying they didn't have to follow Brown versus Board of Education. We'll follow it when it gets to us, they would say. And so we had hundreds of school desegregation cases going. And then as the law evolved or expanded, we got public accommodation cases, we had voter cases. We were just almost broke the course down. We never did break down, but it was tough going. So what you have to say is that that in a country like ours, we are law-abiding, and when we find out what the law is, and we know the Supreme Court is the last authority, and the only thing we have a right as a citizen to do, I think, is to try to get a rehearing, to try to litigate the same issue if you think there's a reasonable chance that the court might change, reverse the previous position. But as a citizen, we should follow the law once it's handed down by the Supreme Court.
I think there are a couple of questions here that Judge McCree would like to answer.
Well, I might not have volunteered to answer them, but I'll do the best I can with them. One of the questions is, in your opinion, is there a reasonable justification for Attorney General Edwin Meese's challenge to the incorporation of the Bill of Rights into the wording of the 14th Amendment? I suppose before I answer that, I should suggest that the 14th Amendment, which is one of the Civil War amendments, provides that, among other things, that no state shall deny any person within its or under its jurisdiction due process of law.
Rather profound question.
And the question becomes, what does due process of law mean? Supreme Court Justice Hugo Black said due process of law meant the substantive content of the Bill of Rights, the first 10, well, the 8 of the first 10 amendments. And it meant that these were binding on the states just as they were binding on the federal government. Justice Felix Frankfurter thought that only those rights which were fundamental, which in his view did not include the entire Bill of Rights, were incorporated in the concept of due process of law, and only those were binding on the states by reason of the 14th Amendment. Attorney General Meese denies that there is any incorporation, at least he has on occasion, of any of the Bill of Rights within the 14th Amendment, and therefore, particularly, the guarantee to be free from unreasonable searches and seizures, or the right to not to be compelled to incriminate oneself that's popularized by the Miranda decision, are not binding on the states, and this is the position that he has taken. I would say that the train has left the station as far as Attorney General Meese is concerned, because the Supreme Court has already decided that the 14th Amendment does obligate the states to recognize these rights, and that they're incorporated whether the rest of the Bill of Rights is incorporated or not. Now, that is not to say that the Supreme Court may not reconsider what it has done, but until it does so, this is the law of the land. The supremacy clause of the Constitution says so, as well as a case called Cooper versus Aaron, which is a case to which Judge Bell made reference in the answer to his previous question.
Judge Bell, you
Take one of these.
Yes, please.
Should there be further measures to curb the power of single interest lobby factions to influence legislation, such as mandatory disclosure laws or ombudsman? I would not favor any measure to curb these single interest groups. They may be disturbing, but that's part of our First Amendment rights to petition the government for our grievances. And if we tried to curb some groups, then where would it stop? And who would be a faction? I think we can't do that. I like the way they do it over in London, where people go out in Hyde Park and make those speeches on Sunday. That's the way I think a country ought to operate if it's a representative form of government. You got to say something to the representatives. So I wouldn't do anything more than what's going on now. The other one is, and this is a tough question. How would you argue the issue of drug testing as a conflict between individual rights and public safety as it relates to the Fourth Amendment right against unreasonable searches? I don't think it's a Fourth Amendment problem. I think it's a right of privacy question when you tell your employees to line up, getting ready to test you. I'm not saying it's a Fourth Amendment problem, unreasonable search or seizure. It's not that. The police are not doing it, it's the employer doing it. Now, it could be the government if it's a government worker. What's happening, because this is such a ticklish question, when a lot of people are being knocked out of getting jobs. You have to take a drug test at a lot of places as a condition of getting a job, and some places the rate sometimes as high as 50% failure because of drug testing. I have an idea that you could have drug testing on a random basis if you were making shells for the military, or if you were flying airplanes. Public safety type situation. I think that it would not have to, I think random sampling testing would be about as far as you could go. I'm not saying that would stand up, but the drug problem is a very grave problem, as you know from the Amtrak train wreck. And it seems to me that the public safety has to be given a good deal of weight. So the minimum interference, the way I would approach it, might be in sensitive jobs to do random sampling. And there's nothing wrong with giving a drug test as a condition of getting a job. You can do that.
This is a question which is addressed to me, a rather profound question. How revolutionary was the creation of the American Constitution vis-a-vis other governments in place in 1787? I might say that in 1787, other governments in place were mostly absolute monarchies, with the major exception of England, Great Britain, which was a constitutional monarchy, and that the republics that existed in 1787 were very small nations like the Netherlands, then called the United Provinces, and the Swiss Confederation. There had never been, since the time of the Roman Republic, which as soon as it became large, became an empire, there had never been a republic over a vast expanse of territory that was created by our Constitution. It was believed by the philosophes in Europe that no republican system could survive over a very large scale. So that in that respect, in terms of the success of a republican government to rule what was a large continent at that time, at least more than a third of continental United States, and to expand to include the great area that it now becomes, was revolutionary. But to the extent that the Constitution was delivered without a Bill of Rights, although bills of rights were incorporated in most of the state, not all, but in most of the state constitutions, it was regarded as not revolutionary and with considerable disappointment by French radicals and philosophes. And they, largely influenced by Thomas Jefferson, who was American minister to France at that time, did draw up their own Bill of Rights, which actually coincided in time, but they didn't know it, with the adoption by Congress of Bill of Rights in America in 1791. And these bills of rights actually provided for a more egalitarian base and for more civil liberties than our original Constitution did. So that to that extent, the French Revolutionary Constitution, short-lived as it was more revolutionary than our original Constitution. McCree.
This is indeed a profound question, which I'll read and endeavor to answer. Under what constitutional basis is the president ever allowed to refuse to spend funds appropriated by Congress and signed into law in the light of the 1970s Supreme Court ruling against Nixon on impounding appropriated monies? Reference has been made earlier this evening to a so-called political question. And a political question, at least one definition of it, is a question which courts do not seek to answer. The Congress has the sole power to appropriate funds and to indicate their purpose. And the president has taken an oath to see that the laws shall be carried out, shall be executed. No one can compel the Congress to appropriate funds. That's something vested in their sole discretion. And it would be almost equally difficult to force the president to expend funds that were appropriated, although he's taken an oath to faithfully execute the laws. The answer to problems like this is necessarily a political answer, and the electorate must be called upon to convince the president what his clear duty is. The specific answer to the question is there is no constitutional provision that can compel him to do it, and I can't imagine the court commanding him to expend funds, except in the narrowest of instances where I doubt if the problem would ever arise. I mean, when I say the narrowest of instances, I mean if an individual person, say a veteran, claims he's entitled to certain benefits and the government resists his claim and the court determines his entitlement, it will tell the government, yes, pay this person that money that we've said is owed to him. But as far as money across a broad scheme of government for a purpose, Social Security, hospital, health care or something, the Constitution just would not work in a situation like that.
Is there another one that you like to consider?
In your view, are any of the recently proposed constitutional amendments, such as ERA, budget deficits, abortion, worthy of serious consideration? The ERA was a raging subject issue at one time, and I believe that the Supreme Court has gradually made it possible for a woman to have every right that a man has. If there's something out there that it hadn't been accommodated, I don't know what it is, but so I think the ERA issue is probably losing steam. The deficit, everyone's worried about the deficits. The budget's only been balanced, I think, 1 year since World War II. Jefferson said that we ought to balance the budget at least once every generation. He considered a generation to be 19 years. Said it was not fair to saddle debt on the next generation. And said in addition to that, it would keep down the dogs of war. He'd seen a lot of monarchs who had spent a lot of money on wars which were not necessary. And he said if you didn't have money, he called it the dogs of war. I think we're within one state now. Montana adopted a balanced budget amendment one day this week. And I think we're within one state of having some kind of a balanced budget proposal. This will be something that has to be carefully handled because you couldn't balance the budget every year. If we were having a recession, for example, revenues fell off or you had need for extra money, or if we're having to expand the military, but some people have suggested, which is that you ought to do it on cycles, like if you added 5 years together, the whole 5 years would be in balance. But this is a most serious movement to amend the Constitution in this country, I think, is on the budget. And a lot of it has to do with these huge deficits that people are seeing now. Now, on the abortion, I think I'm cautious enough just to let that go. I don't believe I'll get into that question. Yeah, that's a no-win. Here's another question. Somebody said, how could I, Mr. Bell, use the dread word prerogative about the president's foreign policy power? This person said he thought this one out with Charles I. It's not in the Constitution, or do you find it there? No, I don't find it there, but it's in the Supreme Court decision. I think it's called the Curtis Wright case, outlining the president's power to conduct a foreign policy. The next one is, did the Supreme Court assume the power to construe the meaning of the Constitution itself in Marbury versus Madison? The answer to that question is yes. That was an open question. And John Marshall wrote to the opinion. And I've always thought it was peculiar that after he said the court had the power and wrote at length about this newly found power in the Supreme Court, he then said they didn't need to exercise it in that case. So I would say that was a politic approach to assuming power. They did it later, you see.
I agree with Judge Bell's comment about Marbury versus Madison, and I'm tempted to add the footnote that Justice Jackson is supposed to have said once, we're not last because we're infallible. We're infallible because we're last. And when the Supreme Court had assumed the last word on a question, it became infallible at that point.
Where would we be if we didn't have, if it was not settled who would finally say what the law is? We'd have, if you think we're having chaos over Iran and Nicaragua, we'd never have any stability if we didn't have one place that could say what the law was.
And as Jefferson said, I guess it was Jefferson, Professor Morris would know this better than I, and where better to put that power than with the least powerful branch of government that has neither the purse nor the sword. And so its edict will be accepted only if it's persuasively presented. And if it doesn't have a constituency for its result, it's in trouble.
I'm afraid that's Hamilton.
Is it Hamilton?
Yeah, I think that's
You see,
the least powerful.
I learned caution at an early date and deferred to him before I took a chance.
That's
the Federalist Papers.
That's one of the Federalist Papers.
One of the Federalist Papers around 81, where he talks about the judiciary as the weakest branch of the government, but assumes that
The least power.
Least power.
But that was before John Marshall's decision.
Before John Marshall. Jefferson, I don't think would have agreed with that, you know.
Well, he certainly didn't after he became president.
No, I think that's so. Do you have other?
I have a question.
Yeah.
What does the Solicitor General do? I'm tempted to tell you that Judge Bell and I belong to a club in Washington called the Alfalfa Club that meets once a year, and the official logo goes something like this. What does the Alfalfa Club do? And the answer is not much. Well, actually, the Solicitor General does, and it's a long story. I'll try to make it very, very brief. The Solicitor General is an officer of the Department of Justice. It was created in 1870 to assist the Attorney General, who before that time had no assistance. He didn't even have an office before that time. But they created the Department of Justice and made the Solicitor General his subordinate to assist him in his duties, and he did pretty much what the Attorney General asked him to do, in addition to arguing the cases of the government in the Supreme Court. Today, he decides what cases the government will take to the Supreme Court, in what cases the government will authorize appeals from adverse decisions in inferior courts, and either he or someone he designates argues the cases presenting the government's view in the Supreme Court. And that's the short form, and
That's what I think it
it's
is.
impossible to tell you any more this side of 30 minutes, so I won't.
Why did the framers of the Constitution allow for even the suspension of habeas corpus? Suspension, what's it say, suspended in time of war?
Yeah.
Yeah. Wasn't this a contradiction? Well, in fact, the habeas corpus law became quite a nuisance for President Lincoln,
Yeah.
and he suspended it. After the war, I know a lot about this because of where I live. We refer to it as the War of Northern Aggression. But there were many people locked up by the Army. The Army was there 10 years occupying the South. And one of the people who was in prison was an editor of a newspaper in Mississippi. And he filed a petition for writ of habeas corpus, and the
Ex parte McCardle.
ex parte McCardle, and the government apparently was worried about it, so they took away the power of the Supreme Court to pass on a writ of habeas corpus. And that was what lasted for several years, so it's not only the president that suspended it, one time the Congress suspended it, but it's our greatest right, I think, because if you divide our rights, the great rights to me are the rights the people have against the governors. And if you look at the Constitution of the Soviet Union, they have more rights than we have. But if you see how they operate, where there's no writ of habeas corpus, and if they say that a crime is a crime against the state, all your rights are gone. They can't challenge the governors. I once debated the Chief Justice of the Soviet Union and asked him that question. Of course, it was asked, so it didn't matter, but nobody paid any attention to it. But where is your provision for a writ of habeas corpus? So it's a great right. We don't ever want to lose that right.
You have another question?
I have a question that either takes a very short answer, which I will try, or a very long answer, which I will not. Do you see the Constitution as having a role in facilitating an equitable distribution of wealth and or liberty as a way of attaining full individual and or property as a way of attaining full individual liberty? The Constitution makes no such provision, and I suspect if a government tried it, it would run afoul of the Fifth Amendment, Due Process Clause. But that's the whole evening.
So is this question, which I guess was addressed to me, to what extent do you think the Federalist Papers were written misleadingly in its representation of the Constitution so that it could be passed under the name of a federal document? Well, this is the type of question which you could answer yes or and no. The point is that both Madison and Hamilton were ardent nationalists, but the centralist drive in Hamilton was much stronger than in Madison, and the Federalist drive in Madison much stronger than in Hamilton or Jay. And one can see that in a number of the papers, beginning with about, if I recall, letters 39 to about 51, 52, in which Madison indicates what parts of the government are national and what parts of them are federal. And he attempted to show a balance of federal interest. What the three writers of the Federalists were especially concerned about was that the public should not get the impression that a great Leviathan state was being created which would not protect the states in their rights, their police powers, their rights to militia, and in other respects. And of course, in order to satisfy them, it was necessary, of course, to include in the Bill of Rights protections both to the people and the states which were not delegated to the federal government. I don't believe that either writer was really misleading, but they were writing as very good lawyers and trying to make as effective a case as they could for the presentation of an entirely new plan of government which was both federal and national in character.
Is there a weakness in the Constitution when the government can arbitrarily limit the freedom of an individual like Paul Robeson without judicial intervention? I suppose the answer is twofold. First, there's only judicial intervention when someone initiates it. The courts, as we all know, don't reach out and take care of instances of injustice. Someone has to invoke their jurisdiction. And we'll remember that Paul Robeson was a very fine lawyer, a graduate of Columbia Law School for that matter. And in many instances when he was having problems with the government, I'm not aware that he went to court with these problems. However, I'm not naive to think that he would have reached a satisfactory solution to all of them if he had done so, and maybe that's why he did not. And that's part of the genius of this nation. It comes up with wrong answers sometimes, but it ultimately gets around to what's right. In 1896, in Plessy versus Ferguson, it came up with the infamous separate but equal doctrine, which was demolished beginning with Brown versus the Board of Education in 1954. But from 1896 on, there was that heresy. Judge Bell has mentioned the McCardle case, where the Supreme Court stood still and allowed the Congress to take away its jurisdiction in a habeas corpus case that had already been argued before it and had not yet been, and the result of which had not yet been announced. I don't think if the Congress tried to take the jurisdiction away from this Supreme Court of a matter which it had already heard and had under advisement, that the court would accept that at this point. And I think we have to understand Paul Robeson's experiences in the context of the times in which they occurred.
What effect do you think the findings of the Tower Commission will have on the Constitution? I have not seen the findings, but I can't imagine that they'll have any effect on the Constitution. They might make the executive organize in a better way. But that commission actually was appointed by President Reagan, the Tower Commission. So it's his commission, and I don't think it'll have an effect on the Constitution. What extent do you believe that the timelessness of the Constitution has been a negative factor in allowing it to adapt to modern times? I don't think it's been a negative factor. I think timelessness of the Constitution is a stabilizing factor, but we find that it does adopt to changing times. And that's been true for throughout this century, I think. There have been some bad child labor decisions outlawing the laws that you could against child labor. That was a bad decision, but things changed. The Leo Frank decision on habeas corpus was a bad decision, but Mooney versus Arkansas changed that. So it's a slow process, but you have to remember that stability is important in the government. So it's probably a good thing the Constitution doesn't change every day. Did the War Powers Act upset the balance of power set forth in the Constitution? I've already mentioned the War Powers Act. A lot of people think it upset the balance between the President and the Congress. I don't think so. My experience in Washington was that if you had a major matter and you presented it to the congressional leaders, that you almost got into a bipartisan approach, and Congress would cooperate with the President. We need, I think, to get back, though, to the period that we were in shortly after World War II, where there were some things where the political line stopped. If there were serious problems to our government, you'd tone down the politics and take a bipartisan approach. And I think if we'd do that, we wouldn't be worried and wouldn't have to worry too much about the War Powers Act. Next thing is, what is your thought about what should be done as far as activities of the present situation to the President of the United States? I like President Reagan as a man, and I feel sorry for him. I think I've never felt any more pity for anyone in public office than I did on November 19th when he had the press conference and was not prepared. He needs to get a better staff. He's been elected president. He's the only president we have for this year and next. And I'd like to see him get some people over there in the White House that were good and would give him support. That's the only way the country can come out of it, as I see it. I'd be glad if they get through the investigations. We've got so many going. It's been great if we could just have one or two. But they'll just have to run the course, I suppose. But we got a lot of things that need doing in this country, and I wish we could get on with some of those.
The Supreme Court seems to be saying that racial quotas may be appropriate as, quotations, temporary, close quotes, measures in certain circumstances. How are private citizens to behave in response to such unclear guidelines from the courts, especially since the courts seem so closely divided in such cases? That's a very difficult question, and the courts are dealing with one of the most difficult questions of our times. That is, how do we correct the consequences of a century or more of discrimination, segregation, and mistreatment without making other citizens today bear the full burden of the corrective measures. And that's really what quotas do, I suppose. If they disappoint someone in his anticipation of job entry or promotion or academic entry and so forth, to permit someone who for 2 or 3 generations back had been excluded from a chance to do this. And it's measuring the rights of equally deserving people in which one has to come out ahead of the other, and it's a very difficult thing. I think the reason the courts are almost equally divided is because there are no clear answers to it. It's a difficult period for the country to go through, and it's something difficult that we have to face. But like other sometimes insoluble problems, we can't abandon it in midstream, if I haven't mixed a metaphor too much. The Bakke case, of course, is the case that comes to mind, and most recently the case of the Alabama State Police. And who's to say where the burden shall fall in a case like that? And that's why the decisions are mostly 5-4. It's the kind of thing that we'll have to outgrow, and I think we have the resilience to do it. The rest of the answer would take the rest of the evening.
Mm-hmm. To what extent did the direct election of senators increase popular influence on government? This has had a very drastic effect on the government. It was the beginning of the downgrading or the weakening of the states' role within the federal government. Before this amendment, the senators were all elected by the state legislatures. Now they're elected by all of the people of the state. And that was a big change. It took many years to get the Constitution changed in this respect. It would always pass the House, but not the Senate. And finally, the states started a movement within the state legislatures to ask for a convention to do it. And when they got within one state, just like this balanced budget I just told you about amendment, Congress then promulgated the amendment, sent it out, and it was ratified. Does our free press account for, in a large degree for the strength of the Constitution? The strength of our government altogether, not only the Constitution, but the government. If it were not for the press, I sometimes shudder as to what the result would be. The press is, I call the fourth branch of the government. I never have any complaint with the press, except the press will not criticize each other. They will criticize the government. And I used to, when I was in the government, ask them sometimes why they didn't criticize each other. If they're the fourth branch of the government, they ought to write about themselves sometimes. But we couldn't, we'd have a very poor government if we didn't have a free press. So we can be thankful we have a free press. What do you attribute the difference, to what do you attribute the difference in the role of the executive branch today compared to the position originally designed? The government, of course, is more complex. The world is more complex now, but there's a vast difference in the way the government functions. In the early days, George Washington, for example, had a small cabinet, all strong people, and he let them vote on things. He'd say, "What do you think about that?" And they would vote. That went on all the way up through the Lincoln administration. Now we have so many people in the cabinet, they wouldn't be able to vote. They wouldn't be informed enough to vote. They're not generalists. And that makes a big difference. So that creates a rise of the White House staff. The White House is calling. And that's power that most people can't handle. And there's too many people in the White House. In fact, all the staffs in the Congress are too large. But you never know who's writing things. Somebody said in the Tower Commission, one of the memoranda they had in the computer at the NSC was General Vesey, who was a great World War II hero, commissioned on the battlefield in Italy. They said he was a wimp. It was some underling over in the White House because they didn't want to send some soldiers into some country. That's the sort of thing that happens. There's too much of a bureaucracy in the executive. It's just in the White House, to say nothing of all these cabinet officers. You can tell how the government functions pretty well by the kind of airplane the cabinet officers get. The lower rank in the cabinet, the larger airplane you'll look for. And the higher, the more you worry about your budget, you try to get a prop plane instead of a jet, that sort of thing. But we could stand some reorganizing, and I would cut out about half the cabinet positions, and I would start diminishing the government by 5% a year for a while, and see what would happen. There's supposed to be one worker in the Department of Agriculture now for each 8 farmers in the United States. So.
Before we're getting close to a closing question, but I'd like to answer this one very briefly. Why did the Federalist Papers fail in the sense that New York was not in the original 9 states for the ratification of the Constitution? Well, the Federalist Papers had nothing to do with that. The states that ratified the Constitution first were the small states, because they had gained in the Connecticut Compromise by getting equality in the Senate, and they were elated by the Constitution. By those, I'm not including North Carolina and Rhode Island, who were holdouts. The large states in general, there was a battle between upstate people, the interior of the country, and the urban areas, and these battles were evident in Pennsylvania, in Massachusetts, and Virginia, and New York. Since the New York Convention did not begin until well on in June of 1788, it certainly did not take them an unusually long time, and since they were battling against tremendous odds of opposition, it seems to me that securing ratification on July 26th represents with more than deliberate speed. Judge McCree, possibly both you and Judge Bell would like to make brief closing statements about these questions?
Only for my part to say that these questions show the kind of curiosity, the kind of interest, the kind of intelligence that gives me reason to believe that someone, not the 3 of us here, will be up here for the tercentenary of the Constitution.
Well, I said in my opening remarks, I'm really thrilled at the interest people in our country are taking in the Constitution. This kind of meeting is going on all over the country. There was recently a meeting at the University of Georgia for 2 days on the Constitution, and it ended up with the last half day was a constitutional convention. And they had the question before them as whether the Constitution should be amended in any way. They had 3 amendments. There's all the balanced budget and a 6-year term for the president, and an age limit on Supreme Court justices of 77 and a half. I asked this law professor how they arrived at that. He said that's half. That's the middle point between 75 and 80. That was a debate.
May I say in conclusion that we are honored by the President's presence of 2 such distinguished public servants who have dedicated themselves for many years to the nation's welfare and have shown a great mastery of constitutional judgment and prudence, and have enlightened us so very much this evening in our continuing symposium on the Constitution. Good night.
Thanks for listening. For more information on the 92nd Street Y, New York, and all of our programs, please visit us at 92ny.org.